Hello, this is me again, Sasha Struthers. I am doing this video and it's 1.5 million degrees outside because we have a heat wave in Los Angeles. So I'm going to do my best to get through this, but it's super hot and I turned off the air so that you wouldn't hear it in the background of this video. So we're going to see if I can manage this. I'm like sweating profusely, so I'm sorry. But I wanted to do a video about DFEH because I've been getting a lot of calls lately about DFEH cases and the rise of those. So we're going to go into what the DFEH is for landlords and how that affects them and the basics of that. So I'm just going to get into it. The DFEH is the Department of Fair Employment and Housing. It governs complaints dealing with employment law and with housing law. And at the core of the agency, it's to uphold the Fair Employment and Housing Act, which is the actual law. So the department, and they enforce the Fair Employment and Housing Act. At the core of that act is to ensure that there's not discrimination, retaliation, harassment in the employment venue and the landlord-tenant venue. So today I'm going to talk about the landlord venue. There has been more and more DFEH cases being filed. Tenants and prospective tenants both can bring complaints. So those are people who have applied and didn't get approved for a unit, they can file a complaint, or tenants that feel like they're being discriminated against, their lease is not getting renewed, etc., they can also file a complaint. So I have my handy dandy notes here. Some of the common practices of discrimination, I've seen it where people have brought complaints because they didn't get chosen for their application wasn't chosen to rent a unit, so they brought complaints. I've seen it where people have applied and they brought complaints because they didn't get selected due to having an animal, and they claim that it's like an ESA animal and they were discriminated against for having a disability, and this, they were protected because their ESA animal was protected and therefore they couldn't be discriminated against. That's a common one that I see. Some people, some landlords will not renew leases and for a number of reasons, and tenants have complained, I didn't get renewed because I was being discriminated against. So I'm going to read through the actual notes so I don't fumble through it of what the common discrimination or retaliation cases are that get brought in the DFEH. So refusal to sell, rent, or lease rooms, apartments, condos, or houses. So this, I'm going to limit it to landlord-tenant, but it can come up in a real estate transaction sense, but this is just going to be about landlord-tenant. Like I said, refusal to negotiate the renting or leasing of any housing. Representing that there's certain housing accommodations that are not available when they are available or should not be available to deter someone from renting. Cancellation or termination of a lease due to discriminatory purpose. Setting policies, practices, terms, or conditions that by nature are discriminatory. Or if you set them after, let's say a tenant complains about something, then you start changing the terms or the rules, that could be seen as retaliation. Sexual harassment. I've had actually a case, it wasn't a DFEH complaint process, but I had a case dealing with FEHA for sexual harassment that the landlord committed against one of the tenants. So I'm going to add that, I'm interjecting a little bit. Tenants can bring DFEH complaints and the DFEH can investigate it, or the tenant can, or prospective tenant can file a civil lawsuit and name the FEHA as a cause of action that they violated the Fair Employment and Housing Act, and they can bring both. So they can file a complaint with the DFEH and possibly a civil suit. It's more common that tenants will do one and not the other, but they can do both. And the DFEH will be handled by the DFEH, and the civil suit will be handled separately, usually by an attorney. However, the DFEH ruling usually will come before a civil suit is resolved. So just bringing that up. refusing to permit disabled tenants from making changes to their unit to accommodate their disability at the tenant's expense. So the tenant pays for, sorry, it's so hot. The tenant will pay for like certain unit upgrades or things that they need, like ramps or shower handlebars, things like that. The tenants will pay to modify the unit, and you can't refuse them from doing those kinds of repairs, because it's seen as disability discrimination. Retaliate against someone for filing a complaint. So if someone does file a complaint, you can't then start retaliating against them for filing the complaint. And then, overly strict rules that can limit, a tenant in their day-to-day life and how they live in the unit, especially when they have, like children. Like you can't have rules, for the tenants, have children, the children can maybe play in the common area, and then all of a sudden you go, children can't play in the common area. That could be seen as discrimination against families. So to go further in this, you can't be singling out people based on their protected class. And there's about 14 protected classes in California. I'm about to go into them, but that's the idea of FEHA. You don't want to be discriminating against tenants for them being part of a protected class. You don't want to refuse to rent to people for being part of a protected class. And you don't want to retaliate against tenants for complaining or exercising their rights. So it gets very sticky. A lot of landlords don't even know that they're discriminating. They'll make business decisions, but that could have underlying adverse effect to the tenant that could be interpreted as being in violation of FEHA. And I see that often where clients are not trying to violate FEHA. They don't know that they're violating it, but the DFEH will investigate and might find that there's a potential violation. So we'll get into the complaint process in a little bit. I'm going to go over what the 14 protected classes are. So I'm just going to list them off. And in the description box, I will also include a link to the actual FEHA. So you can, if you want to nerd out, read it. Or you actually won't be nerding out. That's like a very prudent landlord decision, which is to read FEHA. You might want to read it and see what you're being subjected to and what your rules are. But the 14 protected classes, I'm sorry, it's so hot, is race, color, religion, sex and gender, which includes pregnancy, childbirth, breastfeeding, and or related medical conditions, gender identity or gender expression, sexual orientation, marital status, medical condition, including genetic characteristics, such as a tenant that has cancer or has a history of having cancer in their family, which I know seems like a stretch, like that you would discriminate on that, but discrimination has happened for crazy things. Military or veteran status, national origin, ancestry, disability, either mental or physical disability, including HIV, AIDS, cancer, or genetic characteristics. So that's kind of piggybacking on the medical condition as discussed before. Genetic information, which again, kind of went over it, which is them having some sort of genetic characteristics. And age, people over the age of 40 cannot be discriminated against. Also in California, people's immigration status, it's kind of included. It's a little tricky under national origin. It includes language use and possession of a driver's license issued to persons unable to provide their presence in the United States is authorized under federal law. So if a tenant cannot, or an applicant can't, necessarily prove that they're here legally, it's a very gray area to not allow them to rent an apartment or try to evict them or, not renew their lease because of their immigration status. I would not venture into that territory, but those are the 14 protected classes. Now, okay, I already made the suggestion. You should read FEHA. I will link it below so you can find it. There's also the DFEH website, has a lot of like pamphlets or pretty good resources. I'll link some of those below. There's usually like 1 or 2 page flyers about what rights people have, so you might want to read those as well. Now, the complaint process. The complaint process, when someone files a complaint with DFEH, this is not necessarily having to do with if someone files a lawsuit citing violation of FEHA, but if this is where the tenant or prospective tenant goes to the actual agency. How it goes is a complaint is filed. The agency will do an intake process. They'll draft up a complaint saying this is what this person is alleging the landlord has done. And then they usually have a list of about 20, a little over 20 document requests. And then that's when you respond to the allegations. You can give your side of the story, and then you turn over the documents that they're asking, and they start to investigate the case. They do have subpoena power, so if you don't give them documents, they may subpoena, applicable, like let's say agencies or vendors. Usually it's like an agency, so if they can't get a document, they'll request it. Like usually, like if you can't get a Section 8 contract, they might go and subpoena Section 8, the applicable agency. So then that's where you want to make sure you really know what you're saying or get representation and filing the response, because you don't want to open a can of worms on yourself on why you did or didn't do a certain action as being alleged against you. And the DFEH is supposed to be a neutral party. Sometimes they are, sometimes they're not. Humans, govern humans on this planet, so being neutral, I take with a grain of salt in just about anything. But the idea with the DFEH is they're supposed to be a neutral third party investigating the case. So they're supposed to look at both the tenant factors and the landlord factors and what went down. And I've seen it where the DFEH has found that the tenant's case doesn't have merit, but before you get there, usually they investigate it. It depends on who's assigned to your case. Some people are really slow investigators. Some people kind of push the case along and are pretty quick about it. And then they will always but they will offer mediation. And in the mediation, it's another attorney in the DFEH who also is neutral and tries to get the parties to solve the case and resolve it. Mediation is the same no matter kind of where you go. It's the same concept. We will point out the strengths and weaknesses of respective cases to the other party in the hopes that we resolve it, usually involving, in this case, the landlord paying the tenant or prospective tenant and solving the case. If the case solves at mediation, there's no final ruling or determination, but the matter is resolved. If it doesn't resolve at the mediation or the parties don't agree to it, because both parties, in order to go to mediation in the DFEH, both parties have to agree to go. So the person who filed the complaint and the responding party have to agree, yes, we will go to mediation. Usually that gets brought up after the initial intake of the case and the initial response from the landlord and document gathering. Then they'll go, okay, would you like to go to mediation? I think I'm like most lawyers where we think everything should settle and resolve at mediation because, there's risks in the unknown and you never know how the DFEH is going to rule on a case. They might think that the case is very strong. They might think the case is super weak. You're not going to know really until there's a determination when you're a landlord. If you're a tenant, I've represented tenants in the DFEH, and they will tell a tenant, we don't think there's a case here. That was my experience, and you might want to resolve it. Otherwise, we're going to issue a ruling that finds that there's nothing here. So, I've had cases on the tenant side, I've had cases on the landlord side. And they will let the tenant know if they have a strong case, but they don't usually let the landlord know if the tenant has a strong case or not. So, you know, it's neutral to a degree. But it's very informal, but like anything, someone's accusing you of something and it's stressful. And if you are being, if a complaint is being filed against you, so you're the respondent, you're the landlord or prospective landlord, then you want to reach out to an attorney and tell them the story and, you know, get like a proper answer in. You don't want to not respond, because then usually that results in some form of default and it's like an automatic fine for the person filing the complaint. So you don't really want to get on that track with your case. But it is very much a standard in most areas of California law, even though it's like a preponderance of evidence standard, which is a civil case, a civil matter, a complaint like this. You will always kind of feel like you're guilty until proven innocent. And so when you have a complaint like this, and that's just kind of the reality, I can't undo that, but that's how it feels. So in matters like this, you want to make sure that you talk to someone who's experienced with it, who's familiar with FEHA, and they can, you know, give you a realistic look on, you know, do we think there's something here? Do we think we can defend against it? Do we think we have, you know, the ability to prove that there is an alternative means as to why you made the decision you made that wasn't a violation of FEHA? So there's a lot of things that go into it. But, you know, like all matters, if you're being accused of something, it's scary and you feel offended and you have to defend yourself. So that is FEHA, that is the DFEH. I've seen the DFEH, I've had experience from employment. So I've seen it on both sides there as well, employee, employer. The DFEH doesn't investigate a lot of employment cases, because in that context, it's either DFEH or you file a civil lawsuit. There's not a two-track system. In landlord-tenant, there's a two-track system. So those are becoming increasingly, I guess, more popular, I guess to say. They're now in vogue, where there's people filing those, especially giving the crackdown with, you know, housing laws and not discriminating in housing, given that there's a housing crisis. Now I might be lecturing, I'm not sure, but I have a lot of thoughts on this topic that are kind of outside of this video, which is just a broad overview of DFEH and FEHA. So if you have, if you've been served one of these complaints, or you feel like you're gonna get one, I hope not, but if you've been served one, then you might want to reach out to an attorney. I represent landlords in Los Angeles, so you can reach out to my office. Just to preface, this is not an attorney-client relationship from this video. I'm not giving any legal advice. This is just to be informative, to help you kind of understand what this is and how you should take it very seriously and address it. Okay, it's so hot. I don't think I can surprisingly talk any more than I have, but I hope this has been very helpful. Thanks.